So I am actually here today with Mark Calloway. My name, of course, is Bill Jennings. And as you heard in the intro, I am writing a book. And the title of the book is Fraud Investigation, Forensic Accounting in the Real World. And the real world is the world that I have worked in for the past 40 years, investigating fraud and white-collar crime, sometimes for prosecutors and plaintiffs, but often for defendants, as in the case that Mark and I are going to look at today. I wanted to do these podcasts as a way of helping people to really get in touch with the actual details to the extent possible of the work that was done that you'll see in the book. And I thought the best way to do that is to talk to the people whom I've worked with over the past 40 years, like Mark Calloway. Mark was kind enough to retain me to help him with a case that was a criminal defense case that had to do with accounting. And he and I worked together on that closely for a long time. It was a fascinating case. Mark is a brilliant lawyer. He, incidentally, is today a senior partner at Alston and Bird in their Charlotte, North Carolina office, and is in the white-collar and government investigations practice, which he led at one point. But prior to that, he was the U.S. attorney, so the presidential appointee appointed by President Clinton for the Western District of North Carolina, and then eventually was the director of the executive office at the Department of Justice, which oversees all 93 U.S. attorneys' offices. So quite a storied career. And he also received from Attorney General Janet Reno the Edmund J. Randolph Award for Outstanding Service to the Department of Justice. So quite a long career with the Department of Justice, knows this stuff probably better than almost anyone you'll ever meet. And once again, an honor to work for, and just a terrific professional experience. I learned a great deal. I felt like I grew a great deal in working on that case with Mark, which is why I invited him today to help me with this podcast. So without further ado, I give you Mark Calloway.
Thanks, Bill. You're very, very kind.
Actually not. I'm extraordinarily accurate, which is one of the very necessary skills in my chosen line of work. And so today we want to talk about is a case that was somewhat recently indicted. And I'll just give you the headline. This is from a news release by the Department of Justice. This was actually April 3rd of 2019. Former chief financial officer at publicly traded transportation company charged with $245 million securities and accounting fraud scheme. He was indicted. His name is Peter Armbruster, about 60 years old, Milwaukee, Wisconsin. He was the chief financial officer of Roadrunner Transportation Systems. Along with Mr. Armbruster, Mr. Mark Wogsland, 53, and Brett Naggs, 52, both of Cedarburg, Wisconsin, who were both former controllers of Roadrunner Transportation, were also indicted. Let's see. Okay. All three defendants were charged with one count of conspiracy to make false statements to a public company's accountants and to falsify a public company's books, records, and accounts. 2 counts of false entries in a public company's books, records, and accounts. 1 count of conspiracy to commit securities fraud and wire fraud. 2 counts of securities fraud and 2 counts of wire fraud. Mr. Armbruster and Mr. Wogsland were charged with 1 additional count of securities fraud, and Mr. Armbruster is also charged with 1 count of bank fraud, 2 counts of false statements to a public company's accountants, 1 count of false entries in a public company's books, records, and accounts, and 2 counts of wire fraud. Wogsland's also charged with 2 counts of false statements to a public company's accountants and 1 count of insider trading. Nags is also charged with 1 count of false entries in a public company's books, records, and accounts. All of this, incidentally, happens, we are told, because Mr. Armbruster, who's the CFO, and Mr. Wogsland and Mr. Nags, who are controllers, used, quote, sham accounting entries, misstated accounts, and other means to conceal millions of dollars of bad debts and other financial problems from Roadrunner's shareholders, regulators, lenders, and the investing public. This pattern of deception allegedly caused investors to lose hundreds of millions of dollars. So, and then it goes on to say the Department of Justice and our law enforcement partners are committed to protecting investors and safeguarding the integrity of our markets by holding culpable executives to account for securities and accounting fraud. And I think we could all agree with that statement, but as Mark reminded me before we began in this discussion, it's important to remember that Mr. Armbruster and, Mr. Wogsland and Mr. Nags are at this point innocent because they have not, they've been indicted, but they have not been convicted. And so at this point, again, it's innocent until proven guilty. So we must assume that all 3 of them at this point are in fact innocent, and they won't be ultimately found guilty or acquitted until they appear, either make some sort of plea agreement or appear hopefully at trial to face either a judge or a jury of their peers. And so, you know, we are not in the business, Mark and I, certainly in all the work that we do of concluding about guilt or innocence. That's for a trier of fact and not for us. And so we want to make sure everybody understands that. But with that context, Mark, and I want to note for the record that Mark, incidentally, was co-counsel in a case where an accountant for a public company was indicted on 35 separate fraud counts. And Mark and his co-counsel actually helped that accountant to be acquitted. And so I want to make it clear that just because the government indicts you doesn't necessarily mean you're guilty. So anyway, with that, Mark, let's say you are representing these defendants, or one of the 3 defendants, because of course their interests could diverge. And let's take the man who is the chief financial officer, simply because he's got the most sort of counts against him. What problems does he have going into this?
Well, he has a lot of problems. There's a lot going on here. And one thing you didn't mention but of note is the day after the indictment, the Securities and Exchange Commission filed a civil suit against all 3 gentlemen. So they're also facing an SEC civil suit at the same time that they're facing indictment. And neither of those events, the indictment or the SEC complaint, have come as a surprise to them, because they would have been contacted, their lawyers would have been contacted months, if not a year or 2 before, about the investigation. And so they knew they were under investigation, I would think.
Okay. What would you do? You talked about the fact that they would have known about the investigation, but now they're indicted. And let's just say, for sake of example, that they have been working with other counsel, and now that they've been indicted, you know, it's time to put in someone who is an expert in criminal defense, and so you are retained. What would you do to gain an understanding of the exact nature of the scope and nature of the problems that they're facing?
Well, first off, sometimes the indictment can be a roadmap to what the government intends to prove. This one, it can be called a speaking indictment. So there are enough facts in the indictment that you can get a decent picture of what the government intends to prove. Sometimes you can't do that. Same with the SEC suit. I mean, obviously, There's going to be hours of meetings with your client, debriefing your client to figure out what the facts are. You're going to reach out to co-counsel for the other defendants to see if there's a joint defense arrangement you can enter into so you can share information and facts in a privileged way. Two of the gentlemen who were still working for the company at the time, there was an internal investigation were let go. So you've got to be concerned about what sort of relationship still exists between them and the company, right? Is the company going to indemnify them for their legal costs and expenses? It's very likely that the company is cooperating with the government. It's not unusual, right, for there to be other employees and former employees who are cooperating with the government. So there are a lot of pitfalls out there that you've got to wade through. The most important thing, obviously, is to get a good grasp of the facts. And so you've got to get your hands on as many documents as you can in discovery from the government, right? And hopefully, if you got retained before indictment, you would be able to get some of that from the company ahead of time so you can evaluate the facts to see what kind of problem, if any, your clients got, right? It's not just the accounting entries that you want to see. You want to see emails. What were the conversations back and forth between the defendants and their coworkers and each other at the time these accounting entries were being made or not being made, right? I always like to look at what people were doing and saying when the government's not looking. That's sort of a true test into the sort of heart and soul and mind of the individual. What are they doing and saying at the time the government's not looking? And that'll give you a good idea of what problems you may face. Will there be bad emails? That's entirely possible. Will there be emails that get misunderstood? Sure, you'll have to have an opportunity to explain them. You're also evaluating whether if it goes to trial, you can put your client on the witness stand, right? And that's a decision that can only be made by your client. And so you've got all these things going on at one time in addition to the SEC suit, which may or may not get stayed pending the outcome of the criminal case.
That makes sense. Have you, this is a pet peeve of mine, have you ever been involved in one of these cases where there were not bad emails? Have you ever had one that didn't have bad emails?
I've probably no. Every case has its warts, as I was told one time by a really good lawyer. But there are varying degrees, right? I mean, there are emails you run across that are just awful, and there are some that can just get misunderstood. But right. It's in the emails, and I will tell you, Bill, increasingly now, it's also in text.
Yeah.
That people will text back and forth, even if the company policy is you shouldn't use your personal cell phone for company business. It's human nature, and so there's text back and forth that the government likes to capture, and we like to capture. And you like to take the text and you tie them up with phone records, right, to see who they were talking to and then who did they text next.
Yeah, it's amazing. We live in a world where everything now that we have ever said or done is preserved in some form. I'm reminded of a case I worked on, actually for your firm, different office, but it was a healthcare fraud case involving pharmacies that had a very intricate scheme set up to cause hemophiliac patients to essentially all in one fell swoop exhaust their lifetime benefits under their health insurance policies to buy this particular hemophiliac factor. And the key to that case, interestingly, was Facebook. There is a sort of an online tool that I use that can look at all of the Facebook, front pages, basically, and identify those that contain certain words. It doesn't work well when the words are, words that are highly generalized and are used in many different contexts. But it does work well in a case like this one where the factors themselves have very unique names. And, of course, hemophilia is a genetic disease. And so the people who suffer with it tend to be related. And so using this tool, I was able to identify all these Facebook pages and identify the conversations that people were having on Facebook about the scheme. I mean, it was crazy, you know, like why in the world would you put that on Facebook? But people do it every day.
People do it every day. I've had 2 instances where the cooperating witness, who was also having to plead guilty, the main culprit in a matter, we had on tape, and on from anybody involved in the matter. If so, let's listen to them, see what they say. That kind of thing, because in both of those cases, what was said on tape exonerated my client.
Wow.
After one had falsely accused, in particular, my client of being involved in the person's scheme. And so once we played those for the prosecutors, it put an end to those investigations with respect to our clients. And so there's just like you say, there's a wealth of information out there that's recorded, either audio or video or both, that you need to be aware of and you need to look for.
Yeah. Indeed. So now that you've gained sort of an understanding of, you know, at least the general state of affairs of these defendants in the indictment, what would you counsel them in terms of how you believe you should proceed on their behalf? So what's the right path, I guess, from this point?
Yeah, and so I'd say before you can do that, we talked about gathering the facts, and I want to explain how, in my view, the best way to do that, right? Things develop over time. And so I like to create a timeline of all the key events and facts. I like to get my clients' calendars. You know, where were they? What meetings did they attend? Are there notes of those kinds of things? And develop a linear timeline of what my client was doing at key events, what was done and said, and emails surrounding that. So you can try to get sort of a 360-degree view of the things that were going on at that time and over time. And to really be able to advise your client, you need to have a really good understanding of the facts. We're very fact-driven. I would take that indictment and I would parse it out not only by time, through the timeline, but also by count, and figure out what are the documents that the government has that they will use to prove their case with respect to each count, breaking it down. Who are the likely witnesses for each of those counts? Getting witness statements from the government, that sort of thing in discovery. And if you were representing them before trial, you would be out trying to interview people, to talk to folks, to figure out what the facts are. And so you do that. But I think you have to lay it out for your client. Here are the things you're charged with. Here's the range, the maximum sentence for each. The sentencing guidelines in federal court, this is a federal case, while they're advisory, judges still consult with them and look at them and trying to determine what the appropriate sentence is. So you've just got to lay out for your client what the exposure is. And the fact that the government wins white collar cases somewhere around 80% of the time. It might go up and down in a given year. So your odds of being acquitted are not in your favor, though it can happen, obviously. And if there are cases that need to go to trial, you take them to trial because the government, quite frankly, is just not always right about that. You're far better off if you can get involved ahead of time, develop the facts, and make a presentation to the government to show them that what they think the facts are is not correct, and that you can lay out for them what really happened. That's far better than necessarily having to defend a case that's already been charged. But it's got to be aggressively defended, and so you've got to dig into the facts, be able to advise your client, here's what you're facing, and if you get convicted, here's the likely range of sentence you could get by looking at the sentences in that district historically. What are the judges in that district done? What is the judge that the case is assigned to? What has the judge done? In that case, is hire a forensic accounting expert. I'm not a CPA. You're a CPA. This is an accounting case. It's about whether or not GAAP, the rules following generally accepted accounting principles, have been correctly applied, or whether or not the actions taken were in violation of them. And so that's one thing that you've got to do is get you an expert who can tell you what it looks like from an accounting perspective.
Yeah, that I think that's critically important because, unfortunately, generally accepted accounting principles are not intuitive. They are an artificial system created by human beings, and so it's one of those things where you either are very facile with them and know how to apply them to a variety of circumstances, or you don't. And often, I worked on internal investigation years ago where generally accepted accounting principles had been violated, but the client convinced his criminal. I was actually working for the audit committee of the company, but the client convinced his criminal defense attorney that the things that he had done, he had not followed GAAP, but he said he did it to protect the shareholders because applying GAAP would have revealed results that would have harmed the value of the stock. Now, intuitively, that sounds like a reasonable thing, right? A reasonable person might do that. But of course, in fact, the law requires, as you know, 34 Act and 33 Act in a separate way, require that those financial statements for public companies be prepared in accordance with generally accepted accounting principles. And so you can't just decide that, hey, I have this, motive where I believe in my own mind I'm serving the better angels, and so I'm going to deliberately not apply GAAP. And I think that that kind of bright line needs to be well understood before you design a defense for someone, because sadly in that case the lawyer went to the client's criminal trial in federal court with that defense, and it was terrible. I mean, it's terrible. He was convicted on all counts. So anyway, I think that's a great point that you make.
Yeah, you do. And you have to look at, juries have a good sense of fairness, and they know it's about lying, cheating, and stealing, right?
Right.
People, that's really all I know. In a criminal case, it's about lying, cheating, and stealing, and it's my job, to show there wasn't any lying, cheating, or stealing, or if there was, it wasn't my client that was doing it.
Right.
And so you have to take what can be complicated accounting concepts, why people like you, to help explain that to me and a jury. But you have to put those in plain English. And what the government's saying essentially is that people were cheating and messing with the books and records of the company so that the company's financial condition was better than it actually was.
Right.
And as a result of that, when the truth came out, according to the government, the stock dropped like a rock. Right?
Yep.
Takes a big hit. Shareholders lose value that day or over multiple days, and that's the sort of the case in a nutshell.
Yes, indeed.
So you've got to have somebody to explain to the jury why the defendant's actions were in accordance with GAAP, if they were, and just explain everything. In this case, they're accused of leaving bad debt on the books, right? Not writing it off, that it was uncollectible. Also, that they didn't bring reserves down in the income, right? When it was clear that those reserves weren't going to be needed in that amount. And I think also they're accused of deferring expenses to different periods, and also using those reserves as a cushion where they could sort of, I don't know, you tell me if it's the right term, smoothing out the earnings of the company. So
right. Yeah, that's exactly right.
Over time. And so that's the case. And one thing you have to remember too is, one action or series of actions can violate multiple laws, right?
Right.
Because as a public company, they're going to have a public accounting firm, right, come in and audit the books and records, and they're going to want to talk to management, and they're going to want representations from management, a management representation letter that says the books and records are accurate and true, and they don't know of any material misstatements or misdeeds or things like that in the accounting. And so if they not tell the accountants the truth, then that's going to be a crime. If they certify the financial statements, then that can be a crime if that's false. And aside from the conspiracy charge, which is just simply one or more, two or more people making an agreement to violate the law.
Right.
And that can be a problem, right? And then if you've got bank covenants, and that was alleged here, and you're out of trust with those covenants, and you make misrepresentations to the banks, then there's another charge.
Right.
And so that all that adds up, and then on top of that, the government has a forfeiture charge in there, and what that says is we want all the money back that you got, that you profited from this scheme, and that could be the bonuses they receive for hitting earnings targets and that sort of thing. There are allegations that stock was sold knowing the true nature, financial condition of the company wasn't what they were representing it to be. So, like I said before, there's a lot going on here. There's a lot to be concerned about.
Yes, indeed. And I think you've spoken to this already, but in terms of reaching out to the federal agencies involved, what would you do in that regard?
I would certainly do that. And that was something you would hope that if you're engaged prior to indictment, you would have been having conversations along the way with the government.
Right.
One of the things that I like to do is put together a presentation on the facts of PowerPoint and go over and lay it out for the U.S. Attorney's Office. And the thing there that you've got to be really sure about is that you're right about the facts, right?
Right.
If you're loose with the facts, or you make statements that you can't back up with a document or a fact, you're going to lose your credibility in a hurry.
Yeah.
There are times when the government will give what's called a reverse proffer, meaning they will sit you down and give you a PowerPoint, lots of documents, and sort of an outline of testimony they think that will occur to say, hey, your client's got lots of problems. They need to come in and resolve this to a plea agreement. Here's what it is. And, I like to take those and test those and see if they're accurate, and then push back if they're not. And so you want to have that dialogue and try to have a good relationship with the AUSA, the assistant U.S. attorneys that are prosecuting the case. I think that's essential if you can, to have an open dialogue.
As you say this was not you, but many years ago, I had a client. So a lawyer calls me. A lawyer is a very famous lawyer, actually, and went on to serve in the government in a variety of important roles. But at this point in time, he had a criminal defense client who was in the medical durable equipment business and had sold an enormous number of units to people that had Medicare. And it was all based on one physician's diagnosis of these patients. And this was before HIPAA. So he sends me the clinical records and he says, take a look at these. And these are the ones the government sent to me. And what do you make of them? So it's all this one doctor, and it's for 73% of this doctor's patients, they all had exactly the same diagnosis, which would result in them having a clinical need for this durable medical equipment. And so I called a friend of mine who was a physician practicing in the same area and asked him what the odds were that this physician would have 73% of his patients with the same diagnosis. He said, about the same as winning the lottery. So I go back to the lawyer and tell him, bad news, it looks like your guy did it. So he gets me to go with him to meet with the prosecutor. He's going to make a proffer about, what happened. And he and the prosecutor were, good friends. And the prosecutor's also very famous, held almost the highest post you could hold in the Justice Department. But we sit down with the prosecutor, he goes through all this stuff. And it sort of is getting a little bit off track. And so he's getting a little bit rattled. He looks at the prosecutor and he says, if you indict my client, we are going to trial, and I'm going to put him on the stand, and I'm going to make it clear that the government is beating up a moron. As it turns out, the prosecutor agreed not to indict the guy. He he had driven his, incidentally, he was in the widget business and had driven his, through this, you know, super distribution system for his durable medical equipment, was losing, I don't know, hundreds of thousands of dollars on each unit. So driven his company and himself into bankruptcy through the operation of the scheme. And so, you know, that was the other piece of evidence. You know, nobody would commit a crime to drive themselves into bankruptcy, but the prosecutor was I think, moved by the sort of dark humor of the moment and agreed not to indict the guy. So the point of that story simply is to augur your point, which is, you know, most people would think it's, you know, sort of a game of liar's poker, but it's really not. You know, modern, well, let's leave civil aside, but modern criminal litigation certainly should not be a game of, you know, let's hide the cards and surprise each other at trial. Have you had cases like that where, you know, I guess on the positive side, the robustness, if you will, of information sharing made a big difference?
I have, actually. You know, it's interesting. Your client obviously has a constitutional right not to testify, right? And doesn't have to talk to the government, either before trial or during trial or any time, if he or she does not want to. You have to evaluate if you have a really good defense. So it's pre-indictment, right? And you're salivating because you're thinking at trial, this is going to be great, right? I'm going to lay this on the government, and you know, we're going to win. Till trial, if it would really make a difference with the government, is doing your client a disservice, right? So for you to be able to use that defense, you got to get your client indicted. That's the last thing you want to do.
Right.
And so if you've got a good defense, the time to lay that out is before trial. Right. If you've got a prosecutor that's willing to listen. Now, if I'm convinced for some reason, and it's very few, that the prosecutor's got a closed mind and there's nothing I can do to change it, well, then you're not going to lay your defense out for somebody that's close-minded to it. Why would you tell them before trial what to do? But the vast majority of prosecutors are fair-minded and reasonable people and want to know whether or not they have a bad case or not. They don't want to make a mistake and indict somebody that they shouldn't indict. And that's why I like to dig into the facts, so that if you've got good evidence to prove your client is not guilty, then put that together and present that to the prosecutor to see if you can avoid indictment. And I've been successful on a number of occasions of doing that. Also, too, you have to make a decision. You know, if I'm the prosecutor, I very well may want to talk to the subject of the investigation, the potential defendant, and so you've got to make a decision whether or not you're going to let them do that. Mm-hmm. There are many cases that you don't, and there are some cases that you do. And I have on more than one occasion surprised the government, I think, when they thought they were going to call my bluff, and I said, "Was there anything else that we can do to provide you with information?" And her response was, "Yeah, let me talk to your client." And I think what she thought was I was going to say, "I'm not doing that." And I said, "You know what? I think that's a pretty good idea. Let's do that." Because I already knew that my client was willing to do that, and I was pretty convinced that the facts were on our side and that they really needed to hear from this person to evaluate them as an individual. The story, and we did that, and we were successful.
Wow.
So you gotta take some risks sometimes, but you gotta know the facts, get your client very prepared, and if I've done my job right, and if you've helped me do my job right, then our preparation session with the client is going to be worse than the session with the government. We're going to get them ready. But that kind of thing doesn't happen every day.
Yeah, and you know, as I think about that, that is the sort of strategy that requires an enormous amount of judgment, supported by many, many years of experience. And so would not be something, you know, that would be an area where you would, as a client, you'd want to make sure that you had someone who had been down that road before many times and knew, you know, wasn't sort of speculating or guessing, but knew how things turn out in a variety of different scenarios. So I think that's a very good point.
Yeah. The last thing you want to have happen is your client to lie in an interview, or for the government to think they're lying, because they could be charged with what's called 1001, like lying to the federal government.
Right.
You don't want that to happen. And there are a variety of ways you can approach that, but that's, sometimes that might be the only way you can avoid an indictment.
Yeah.
Your client's side of the story out and back it up with facts, with documents.
And the client, the government, in fact, uses that statute, not, all the time, but with some regularity. I remember there was I think it was a congressman, elected official here, whose his last name, unfortunately, was Swindoll. But he was interviewed by FBI agents about a conversation that he had with a member of organized crime, and he lied to the agents about it. And this is a point I just want to make, because when people watch this, I want them to realize how this happens. They, of course, the FBI, because it wasn't their first rodeo, had a video and an audio recording of him meeting with the organized crime figure, which, of course, they always do. And I have seen people get into far more trouble. I've had a lot of clients who gotten into far more trouble trying to cover up their crimes than they would have if they had simply dealt with whatever conduct it was that they were being investigated for. In his case, he was indicted, convicted, he appealed for years and years and years, but finally, went to federal prison, because it's, who are you going to believe, me or your lying eyes? I mean, they had him on video. And that's often the case, Mark. I'd like to hear your viewpoint, but I worked on another big criminal defense case here where federal agents show up at the home of the brother of one of the defendants. And they say what the federal agents always say, which is, we want to ask you a few questions. And he says, of course, I have nothing to hide. Then he says, do you mind if I record this? And of course, like all federal agents, they say, of course, not at all. Please record it. So he brings out a recording device, turns it on. And of course, federal agents train in this area a lot and do a lot of on-the-job training. But they always start with the things you're comfortable with. Where'd you grow up? Who's your sister? All that stuff.
Right.
And then it's only in 10, 15 minutes or longer into the interview that they get to the information that they're really interested in, which is what they do with this guy. The minute they hit the question that is related to his brother's conduct, he says, wait a minute, let me turn this off. And he turns the tape recorder off. Now, of course, the federal agents continue the interview, and they prepare, 302s, which of course the FBI's sort of gold standard interview report with their interview notes attached in an envelope. And of course, that becomes, I guess the best record of hearsay, if you will, of what happened in that conversation. But it really, his brother was ultimately acquitted, but it really, really complicated the defense in that case. And I think it may have been, in fact, one of the reasons that the prosecutor was not able to, find any road to resolution other than, bringing it to trial, which is what they did. Again, they were acquitted, but still, I mean, it was a terrible thing. I don't know what your experience has been with things like that.
I don't think I've had anybody that's done their own recording while being interviewed by agents. So you have lots of clients who get interviewed by the FBI, right? They show up at your house and they knock on the door, and people feel like they've got to talk to them.
Right.
Otherwise, the agents are going to think that they're guilty. Well, they don't have to talk. But if they do talk, what they have to do is tell the truth.
Yeah.
And so, I always advise people, if you're going to be interviewed by the government, don't let yourself be interviewed if you plan to lie. And if you're not comfortable answering questions on just about any topic, unless I can narrow the list in advance, then we don't need to do this interview. You need to be able to to answer all their questions and answer them fully and fairly, and don't play games with an FBI agent, right?
Yeah.
In terms of answering their questions. Because the worst thing for you, as you said, is if they think there's a cover-up. Our saying is the cover-up's almost always worse than the crime, right? And sometimes the cover-up is easier for the prosecutor to prove than the actual underlying offense. Right?
Yeah.
They can't get the offense. People lie about things that they shouldn't because they feel like they've done something wrong when in fact maybe they haven't.
Yeah. I worked on a matter where and again, this was a chief accounting officer, but there was a grand jury subpoena for the emails, right? You talked about the emails earlier. And he deleted almost 5,000 emails, believing that he was somehow destroying any record of the emails, which of course he wasn't. The minute the grand jury subpoena hit, the CIO made a forensic image of the email server. So, he hadn't done any of that, but it was one of the easiest things for the prosecutor to prove. I mean, it was just, it was absolutely, what are you going to believe? I mean, here are the records of the emails he deleted, and it was just a silly thing for him to do. I know we're about to. I'm sorry. I know. I just want to say that I'm watching the time, and I know we're getting close to your hard stop. And I do want to ask you one other question, which is, all of these things. Can you sort of share based on what you know, what the sort of alternatives are in terms of the best strategies for these defendants, as they make their way through the process?
Well, I mean, I think they've each got to make their own individual assessment, right? There's always the risk that a co-defendant will plead, right? And it will get the best deal. The government will tell you there's only one best deal to be had. Right. And that if that co-defendant comes in and agrees to cooperate, then they may testify against you. Excuse me. Try not to sneeze.
Bless you.
You can cut that part out. But you have to. You also have to have a client who can be in for the long haul if they want to go to trial. Sometimes it takes longer for others for reality to set in, but can they withstand the long process? It might be a year and a half of pretrial, discovery and motions, and then you could have a 5-week, 3-month trial out of something like that. Can that person withstand that? I think people sometimes forget about the human side of this. That individuals who get investigated and indicted are under tremendous personal stress.
Oh.
Their families are under stress. If they've lost their job, they've got savings, they can rely on that. If they don't have savings, then how are they going to pay their bills and that sort of thing. And so you have to be, as a defense lawyer, mindful of that and pay attention to that and talk with your client about it. Sometimes I say I'm 70% psychologist, 30% lawyer. Because of all that stress. I mean, It's just, it is. And, and if they're acquitted at the end of the day, that's a great relief. But think of what they went through before that. And if they get convicted, then they're going to be away from their family for a while, and they might not see their kids grow up. And there's the human factor, all the things that people have to take into account. So I think as a lawyer, it's real important. But I wanted to ask you one question, if I could, and that is, when you get hired in a case like this, what's the type of information you need from the lawyer in order to do your job and render your opinion?
Of course, in cases like this, the information tends to come in over time. But the most important thing initially is to understand as best I'm able, what actually happened. And so information that informs that, you mentioned the emails, but also the accounting records, if possible, getting access to the auditor's working papers. Sometimes that's possible, sometimes not. And then, if there have been witness interviews done, being able to look at those witness interviews. And sometimes it's data. Fortunately, nowadays, most things are electronic, and we have some terrific tools. I like Power BI, but there's Python and a variety of others, where you can actually dump in data that may inform you about what actually occurred and create instant visualizations, things that were impossible, even 10 years ago. And what that helps you to do is to really fact check the story, if you will. And so if there's some report about inflation of revenues or all kinds of metrics out there that are readily available that you can dump into these tools to test those assertions. And so that's typically, and then we do a fair amount of research, frankly, still, most of it online now, but sometimes with, private detectives at the street level, to make sure we understand the reality of all the players and their sort of past activities and encumbrances. And I have one I'm working on right now where one of the officers of the company who is accused of a unique form of embezzlement. I did a bit of research and found out he was convicted of exactly this conduct in another state about 10 years ago. And so, while he may not have done it this time, it suggests to me that he at least knows how to do it and, has crossed that threshold before. So those kinds of things. It's mostly getting evidence to check the narrative as we currently understand it.
Real important.
Yeah.
It's all about the facts.
Indeed. I can't tell you how much I appreciate you making the time to do this with me. It's very, very important to me, and I just can't thank you enough.
Happy to do it. I've enjoyed working with you and look forward to the chance to work with you again.
Me too, Mark.
All right. Thanks, Bill.
Take care, man.
All right. You too.
All right. Bye-bye.
Bye.